r/ProRevenge neighbors lies about property line backfire spectacularly. Hashtag chunk 1. I stood in my backyard with my phone pressed to my ear, listening to my realtor's voice crack with nervousness for the third time that week. He's filing a formal complaint with the county, she said. He's claiming you're the one encroaching. He says he has documentation. I looked down at my garden, the one I'd spent the last 3 months meticulously planning. Heirloom tomatoes, heritage carrots, herbs I'd specifically chosen to complement the cottage aesthetic of my first home. My first home. The word still felt surreal in my head, even after 6 months of ownership. That's insane, I said, though my stomach was already doing backflips. He's the one who put up the fence. I know. But he seems very confident. And apparently he used to be a lawyer. Of course he was. Because the universe has a sick sense of humor. I hung up and walked the perimeter of my property line, again. This was becoming a ritual, like checking that the doors were locked at night or obsessively monitoring my mortgage statements. In the weak November sunlight, I could see the bright aluminum fence that had appeared seemingly overnight about 4 months ago, right around the time my neighbor moved in. His name was Gerald Hutchins, and he was exactly what you'd picture when someone says, retired lawyer. Silver hairstyle just so, an aggressive jawline that seemed permanently set in a smirk, and the kind of confidence that only comes from decades of getting whatever you wanted. He'd moved into the craftsman-style house next to mine in July, and I tried to be friendly. I'd actually baked cookies, actual homemade cookies, to welcome him to the neighborhood. He'd looked at them like I'd handed him a live tarantula. Do I look like I eat refined sugar? He'd asked. I should have known right then. The fence line was the first real sign of trouble. I'd noticed him out measuring things with a professional surveying tape one Saturday morning, and when I'd come over to ask what he was doing, he'd looked at me with this expression of pure, distilled pity. I'm establishing the actual property line, he'd said. The one that's been incorrectly marked on your property records. But my surveyor already. Your surveyor was clearly incompetent. I had mine out here. The line runs 15 feet farther into what you call your yard. That strip includes your garden, a significant portion of your driveway, and the mature oak trees you seem so fond of. They're mine. I remember the specific cold feeling in my chest. The specific moment the world tilted slightly. That's not possible, I'd said. I have documentation. From my closing. The survey. Documentation from decades ago, performed with equipment that wouldn't be acceptable today. You appear to be a renter pretending to be an owner. It happens more often than you'd think. People don't understand real property law. He'd smiled then, and it was the smile of someone who'd never been told no in his entire life. My documentation is recent and professional. When my lawyer files with the county, you'll understand what's actually happening here. He wasn't bluffing. 2 weeks later, the fence went up. Beautiful aluminum fence, very expensive, very much marking a line 15 feet into my property. The garden he was claiming. I watched it from inside my house for the next week, too paralyzed to actually go out and touch it. But paralysis didn't last long. It turned into something hotter. I'd hired my own surveyor again, paid for an expedited report, and the results were crystalline clear. Every single inch of that fence, every square foot of the garden, the entire driveway, it was all mine. Had always been mine. I printed the report, walked over to his house, and knocked on the door. He'd barely glanced at it. Second opinion from another amateur, he'd said. Not particularly compelling. My surveyor is from Harrison and Associates, the gold standard in property boundary establishment. I suggest you save yourself the legal fees and start looking at alternative housing solutions. I'm going to be generous, though. I'll give you 30 days to remove your vehicles from my driveway before I have them towed at your expense. The driveway. The one attached to my house. That I used every single day. You can't do that, I'd said, and I could hear the desperation creeping into my voice. I can, and I will. My lawyer is drawing up a cease and desist regarding your trespassing. When you receive it, I take it very seriously. These things can become expensive for people in your circumstances. I'd asked him what he meant by that. He'd smiled again and said, well, you're clearly not wealthy. Legal battles aren't cheap. I, on the other hand, have nothing but time and resources. So really, this is just going to hurt you. Then he'd closed the door. That conversation had been 6 weeks ago. Since then, I'd received the cease and desist from his lawyer, a genuinely threatening document that cited potential financial liability if I continued trespassing on his property. I'd received 2 separate threatening letters. I'd gone through the county records office 3 times, paid for expedited research, and sat across from a property law attorney who cost more per hour than I made in a day. Every single document confirmed the same thing: the fence was wrong. The boundary was wrong. Gerald Hutchins was wrong, and he was lying. But he was also a retired lawyer with money and time, and I was a 34-year-old who'd put literally every penny I had into this house. My savings account was now 6 figures in debt, my credit cards were maxed out for the legal fees, and I was genuinely terrified that he'd figure out some legal maneuver that would destroy me anyway. The attorney I'd hired kept saying the same thing: you have a strong case. A very strong case. But honestly, he's betting you'll give up before it goes to trial. That's his real strategy. And the worst part? It was working. I stood in my backyard, looking at the fence, at the garden that might not be mine much longer, at the driveway I was apparently trespassing on every time I parked my car, and I made a decision. If Gerald Hutchins wanted a legal war, he was going to get one. But first, I needed to know exactly what I was fighting for. That evening, I pulled up the county property records on my computer and started searching. Not just for my property. For his. Hashtag chunk 2. The county records website was poorly designed and infuriatingly slow, but I had time. I had nothing but time and a growing sense of purpose that felt almost medicinal after weeks of helpless panic. I started with the basics: Gerald's property deed, the official survey attached to his purchase documents from July. I pulled it up and felt my first spark of real hope. The survey showed his boundary line clearly marked, and it looked suspiciously close to where I thought it was. I cross-referenced it with my own documents, overlaying the information in my head, and my stomach did a small, interesting flip. Something didn't match. I spent the next 3 hours digging. County records, property tax assessments, utility easements, historical surveys going back 30 years. My coffee went cold. My cat, Mr. Whiskers, jumped on my keyboard twice and I barely noticed. I was building a map in my head, a picture of property lines that existed on paper decades ago versus the ones that existed now. That's when I found the first real anomaly. Gerald's property survey from his July purchase showed his back boundary line running at a very specific angle, 47 degrees northeast, according to the official measurements. But when I looked at the historical records from the county, the original property subdivision from 1987 showed a different angle entirely. 43 degrees. The difference seemed small until I realized what it meant. If Gerald's current line was wrong, and the original line was right, then his property line might be running into his yard, not mine. My hands were actually shaking when I pulled up Google Earth satellite imagery. I could see Gerald's house, his new deck, that beautiful, expensive deck that had gone up in September, his brand new pool house that looked like it had been installed just last month. I zoomed in as close as the image would allow, trying to trace lines that probably didn't exist on a computer screen. But I could see enough. The pool house seemed to be built remarkably close to where a corrected property line would be. So did the deck. I sat back and took a breath. This could be nothing. This could be paranoia or wishful thinking. But it could also be everything. I decided to do what Gerald had done to me, hire a surveyor. Not my original one, I was going to get someone completely independent, someone with no prior involvement in this dispute. Someone, ideally, who worked for a firm with a prestigious reputation. Someone who couldn't be dismissed as an amateur. It took me 2 days to get an appointment. The surveying company I found, Precision Boundary Services, had a 3-week waiting list, but when I explained that I was in an active property dispute with a neighbor, the office manager seemed to take pity on me. She squeezed me in for a Tuesday morning, 2 weeks out. 2 weeks felt like forever and no time at all. During that waiting period, things with Gerald escalated in a way I hadn't anticipated. He installed a gate. An actual gate, at the entrance to what he was claiming was his driveway, my driveway, and it had one of those electronic keypads. I watched from my window as a contractor installed it, and I felt something dark and hot bloom in my chest. The next morning, I tried to drive to work and found the gate locked. I sat in my car, staring at it, and made a decision that probably should have involved calling my lawyer first but didn't. I got out, walked over to the gate, and knocked on it. Literally knocked on a gate like it was a door. Gerald appeared within 30 seconds, which suggested he'd been watching. Of course he had been. I need access to my driveway, I said, keeping my voice level. Your driveway, he repeated, and his smile was sharp enough to draw blood. You mean the trespassing path you've been using on my property? I'm glad you're finally acknowledging the situation. Unfortunately, that particular matter is now in the hands of my attorney. You'll need to contact him regarding access to disputed areas. Gerald, that driveway connects to my house. I live here. For now, he said. Though I suspect that will be changing soon. In the interim, feel free to park on the street and use the sidewalk like a normal person. Or better yet, contact your lawyer and have him reach out to mine. That's how these things are typically handled. He started to close his door. I could call the police, I said. He paused, and for just a moment, something flickered across his face. Uncertainty, maybe, or the ghost of caution. Then he smiled again. For what? Using my own gate on my own property? That would be quite the embarrassing phone call for you. But please, feel free to try. I'm sure the county sheriff would love to hear about your trespassing complaints from another angle. He closed the door, and I stood in his yard, or what he claimed was his yard, feeling a sort of helpless rage that nearly bent me in half. I called my lawyer. He was officially alarmed. He's creating a hostile environment specifically designed to force you into a corner, my attorney said. His name was Richard Brenner, and he was the only thing standing between me and complete financial ruin, so I tried to take him very seriously. It's also technically blocking your reasonable access to your own home, which is legally questionable, but proving intent is tricky. So what do I do? For now. Park on the street. Don't give him any additional ammunition. And keep documentation of everything. Photos, timestamps, any communications. If this goes to trial, a judge will want to see evidence of his escalation tactics. Will that matter? There was a long pause. It depends on what the surveys show, Richard said carefully. His aggressive behavior helps your case, but it's not a substitute for being right about the property line. So that survey appointment you have next week, that matters. That matters a lot. After I hung up, I sat in my car, parked on the street like a visitor to my own home, and I opened my laptop again. I went back to the county records, back to the satellite imagery, back to my theories about angles and property lines. I was right about something. I could feel it. The question was whether being right would be enough, or if Gerald's confidence in his own legal knowledge, that decades of bullying people in courtrooms, would carry him through anyway. The surveyor appointment was 12 days away. I was going to spend every single one of them preparing for war. Chunk 3. The next morning, I woke up with a headache that felt like someone had driven a nail through my skull, and for the first time since this nightmare began, I seriously considered just giving up. Not to Gerald, I wasn't anywhere near that broken, but to the sheer, exhausting weight of it all. My first home. My life savings. Everything I'd worked for since I was 22 years old, and now I was sleeping badly, parking on the street like some kind of vagrant, and spending my evenings drowning in county records that might not even matter. Mr. Whiskers had abandoned his usual spot on my bed and was instead sitting on the kitchen counter, staring at me with the kind of judgment only a cat can muster. Don't start with me, I told him. I called in sick to work. I had the vacation days saved up, and Richard had suggested I use the time to prepare, to gather documentation, to build the foundation of what might become a legal case. What he really meant was, start acting like you're going to war. Because that's what this was. That's what it had always been, from the moment Gerald installed that first illegal fence. I spent the morning organizing everything I had. Every email exchange with Gerald, printed and chronologically ordered. Every photo I'd taken of the fence, the gate, the mysteriously shifted property markers. Every document from my county records search, highlighted and annotated. I created a timeline on a large poster board, the kind I hadn't used since high school, and I covered it with dates and events and connections that probably only made sense in my own spiral of obsession. By noon, I had an organized 3-ring binder that would have made my mother, a retired librarian, actually proud. That's when the phone rang. It was the county assessor's office, returning a call I'd apparently made 2 days ago and forgotten about. The woman on the line introduced herself as Nancy Chen, and her voice had the kind of patient exhaustion that suggested she dealt with property dispute calls every single day. I have your inquiry here about a property line discrepancy, she said. You're calling regarding the property at 447 Maple Street. My heart rate kicked up. Yes. I'm the owner. I have questions about the historical survey data and how it relates to the current boundary lines. Right. Well, I've been looking into this, and I wanted to give you a heads up before you take any action. She paused, and in that pause, I felt something shift. We did receive a formal inquiry about this property 3 weeks ago. From the neighboring property owner. Gerald Hutchins. Of course he had. Of course the bastard had already been to the county office, probably charming them with his retired lawyer routine, probably asking questions designed to intimidate the assessor's office itself. What did he ask? I heard myself say. He wanted to know about the survey discrepancies, the historical property records, the original subdivision documentation. Essentially what you're asking about, but he framed it as a courtesy inquiry. Said he was trying to resolve a boundary dispute amicably. Nancy's tone shifted slightly, became more sympathetic. Which, given what you're telling me, is interesting because he's been threatening me, I finished. He installed a gate blocking my driveway. He's claiming land that's clearly mine. There was a rustling of papers on the other end of the line. I'm not supposed to get involved in property disputes. That's not technically my department. But what I can tell you is that there are some inconsistencies in the records for both properties. And Mr. Hutchins asked some very specific questions about his own survey. Questions that suggested he might already be aware of the problem. What kind of questions? He asked if there was a way to identify when a survey was conducted incorrectly. Whether someone could sue a surveying company for errors. Whether the county could be held liable for inconsistent historical documentation. Nancy took a breath. Those aren't the questions someone asks if they don't already suspect something is wrong with their own property line. I felt something cold slide down my spine. You're saying he knows. I'm saying it's possible. I'm also saying that if he knows, and he's still proceeding with this aggressive approach to claim your land, that's worth thinking about. In a legal context. After we hung up, I sat at my kitchen table for a very long time, staring at nothing. Gerald knew. Or at least, he suspected. That meant his aggression wasn't the confident posturing of someone certain he was right, it was the desperate flailing of someone trying to claim as much land as possible before someone like me figured out the truth. I needed to tell Richard. But before I could call my lawyer, there was a knock on my door. Not Gerald, I would have recognized his car in the driveway. This was a man in a suit, and he had the kind of blank, professional face that immediately made me think, process server. It was worse than that. Are you the owner of 447 Maple Street? He asked, holding out an envelope. I took it without answering. My hands were shaking again, the same tremor from when I discovered the angle discrepancy in Gerald's survey. Inside the envelope was a cease and desist letter from Gerald's lawyer, officially ordering me to cease using the disputed driveway immediately. It stated that any continued access to the disputed property would constitute trespassing and that any attempt to remove, alter, or interfere with Mr. Hutchins' boundary markers would result in criminal charges. But there was more. A separate letter, on the same law firm's letterhead, was a formal demand. Gerald was offering me a settlement. A one-time payment of $12,000 for the disputed 15-foot strip of land. $12,000. The strip included my entire garden and the driveway I used to access my own house. $12,000 for me to surrender access to my own home. It was insulting. It was also brilliant legal strategy, because it created a paper trail showing that Gerald had offered a settlement, which could later be used to argue that I was being unreasonable by refusing reasonable terms. Richard called me back within an hour of me forwarding him the documents. This is good, he said, and I almost fell over. This is actually good. The cease and desist, the settlement offer, this is him playing offense when he's already on defense. This is him panicking. How is any of this good? I asked. He's threatening criminal charges. He's trying to buy me off. Yes. And a judge will see exactly what those things mean. He's escalating because he knows something's wrong. The question is whether we can prove it before the survey appointment on Tuesday. 5 days. The surveyor was coming in 5 days, and everything, my entire future, my home, my life, depended on what they found. That night, I didn't sleep. Instead, I sat at my kitchen table with every single document I had, rereading everything, looking for something I'd missed. Some piece of evidence that would make this all make sense. Somewhere in these papers was the proof I needed. Somewhere in all of this was the moment when Gerald's confidence would collapse, and his lies would finally catch up with him. I just had to find it before Tuesday. #Chunk4. The document spread across my kitchen table looked like the aftermath of some kind of explosion. Post-it notes in 3 different colors. Highlighter marks in patterns that probably only made sense to me at 3 a.m. My coffee had gone cold hours ago, and I'd moved on to something stronger, a bottle of wine that was now half empty and making my thoughts feel simultaneously sharper and more fragmented. I'd been reading the same county subdivision record for the past 20 minutes without actually absorbing any of it. The thing about living in a state of extreme stress is that your brain doesn't actually work the way you expect it to. I'd assumed that desperation would make me sharper, more focused, like those people in movies who suddenly unlock superhuman abilities when their survival is threatened. Instead, I felt like I was moving through water. My eyes would read the words on a page, but the meaning wouldn't connect. I'd find myself staring at a survey date, June 1987, and then somehow 5 minutes would have passed and I still wouldn't know what I'd been looking at. Mr. Whiskers had finally abandoned his perch of judgment and curled up on top of my organized binder, which felt like a deliberate act of sabotage. I needed to call someone. Not Richard. I'd already sent him 3 emails with various attachments and he responded with a curt, "We'll discuss at the appointment." Not my mother, who would spend 45 minutes asking me if I'd eaten and then another 2 hours explaining why buying property was a mistake in the first place. Not my best friend Jenna, who had already texted me twice today with increasingly concerned messages. Instead, I did something stupid. I did something that a sane person would recognize as stupid even in the moment, but I was running on fumes and half a bottle of wine, so I did it anyway. I walked across my own driveway, the one I wasn't technically allowed to use according to a lawyer whose letterhead probably cost more than my monthly mortgage payment, and I climbed the small hill that separated my property from Gerald's. It was nearly midnight. My porch light cast long shadows across the lawn. The crickets were doing their thing. The world was asleep, and I was apparently having some kind of breakdown. Gerald's property was dark. His car was in the driveway, a pristine Mercedes that probably had a heated seat setting for his buttocks. The house itself was a 1990s colonial with hunter green shutters and a kind of landscaping that screamed, "I hired professionals." Beyond the house, the pool area glowed faintly with solar lights along the deck. The pool house sat behind it like a monument to excess. To his excess. To the excess that he'd built, according to my frantic calculations and Richard's grim confirmation, substantially onto my land. I stood at the edge of his property and thought about how nice it must feel to be so certain. To move through the world with Gerald's particular brand of confidence, installing fences and demanding money and threatening litigation without a single doubt that you were in the right. What did that feel like? To never question yourself. You're trespassing. I actually jumped. Like, full body startle, the kind where your entire nervous system misfires at once. The voice had come from behind me, Gerald, sitting on his back deck in the darkness, visible only as a silhouette. I hadn't even noticed him there. "I'm on my property," I said, and my voice came out steadier than I felt. "You're on my property. According to my survey." He stood up from whatever he'd been sitting in, and even in the darkness, even from a distance, I could sense his satisfaction. This was what he'd wanted, to catch me doing something he could use, something he could point to and say, "See, unhinged, unstable, dangerous." "I know what your survey says," I told him. I should have left. I should have walked away, driven back to my house, deleted this moment from my memory and never spoken of it to anyone. Instead, I said, "I also know what the county assessor has to say about your survey." I couldn't see his expression in the darkness, but I heard the change in his posture. The way he shifted his weight. "You've been asking them questions," I continued, and now I was in it, fully committed to this terrible, wine-fueled decision. 3 weeks ago. Asking about surveying errors, about liability, about whether someone could sue a surveying company for getting the boundary wrong. "I don't know what you're talking about." "Of course you don't. You probably talked to your lawyer about it instead. You probably have conversations in his office about what happens if the county records show that your deck and pool house are sitting on my property. About what you do when the person you tried to bully turns out to know how to read county records." Gerald moved toward me, not threateningly exactly, but with enough purpose that I felt a flutter of something in my chest. Fear, maybe. Or just the belated realization that I was alone on someone else's property in the middle of the night, and I just announced that I knew his secrets. "You're making assumptions," he said flatly. "I'm making observations. Based on documents. The same way you did." He was close enough now that I could see his face. He looked older than he had the day I'd moved in. There were lines around his eyes that I didn't remember, and his jaw had a tightness to it that suggested he wasn't sleeping either. "My surveyor is coming Tuesday," I said. "I got the confirmation email. The county has approved the independent survey, and by Wednesday morning, we'll know exactly where the property line actually is. And if it's where I think it is, then your pool house and your deck are a significant financial problem. Your surveying company is a significant financial problem. And your lawyer is going to have a very serious conversation with you about liability. If you're smart," Gerald said quietly, "you'll take the settlement. $12,000. The offer's good until Monday. After your independent survey, the offer comes off the table. And then we'll see what a judge thinks about the value of the land you've clearly built something on. We'll see what they think about your contractor's licensing and whether the permits were correctly filed." He stepped closer, and I finally understood what he was doing. He wasn't threatening me anymore. He was negotiating. Which meant he was scared. "You have until Monday," he repeated. "And then this gets very, very expensive for both of us." He turned and walked back toward his deck, back toward the darkness where he'd been sitting, and I realized I had been holding my breath the entire time. I walked back to my house on shaking legs, locked every door and window, and called Richard first thing in the morning. "Don't," he said immediately, before I'd even finished explaining what happened. "Don't do that again. Don't talk to him. Don't engage. You're playing his game when you do that, and we need to play ours." But I'd already changed something by talking to him. I could feel it. The ball was in the air now. And nobody knew where it was going to land. #Chunk 5. Richard's office was exactly what I expected, mahogany everything, a view of the city that probably cost more per square foot than my entire house, and a kind of silence that only comes from thick soundproofing and people who charge by the minute. He was reviewing the independent surveyor's preliminary report when I arrived Tuesday afternoon, his reading glasses perched on his nose, his expression a careful blank that I was learning to dread. "Your instincts were correct," he said finally, sliding the document across his desk toward me. "The encroachment is approximately 28.7 feet into your property. His pool house, as it currently sits, is nearly 70% on your land. The deck is about 40%. The fence line is also incorrect, he's claiming 3 additional feet on the eastern side." I should have felt vindicated. Instead, I felt something closer to nausea. "What does that mean in terms of everything?" I asked. Richard removed his glasses and rubbed his eyes. "It means we have significant leverage. It also means this is about to get exponentially more complicated and expensive, and not just financially." He pulled out a second document, this one newer, the ink still dark on the page. "He filed a counterclaim yesterday," Richard continued. "Claiming adverse possession." "What does that mean?" It means he's arguing that he's had such open and obvious use of that land for so long that it should legally be considered his, regardless of what the original survey says. It's a long shot, especially since he literally just installed the pool house 2 years ago, but it's a tactic. It's him playing offense now that he knows we have documentation. Can he actually do that? Not successfully, in this case. But he can make the process much messier. He can drag this out. He can file motions, request continuances, and generally make our lives difficult. And Richard paused, which was worse than anything he could have said. There's something else. He handed me a third document. This one made my stomach drop. It was a cease and desist letter addressed to me, claiming that I had been making false statements about Gerald's property and his surveying company, that I had engaged in trespassing with the specific intent of gathering information to damage his reputation, and that if I continued my pattern of harassment and defamation, they would seek damages. He's saying I'm harassing him. The words came out higher than I intended. He's been threatening me. He installed a fence on my property. I know, Richard said quietly. And we can defend against all of that. But it means he's escalating. He's moving from trying to scare you off to trying to make you look unstable. And that midnight conversation you had with him? It's going to be part of his narrative now. He'll claim you came onto his property to threaten him, that you've been obsessing over his business dealings, that you're making baseless accusations. But I'm not, I said. I'm not making baseless accusations. The county assessor confirmed. I know. The evidence supports you. But evidence isn't the same as credibility, and right now, the narrative he's building is that you're a new homeowner who got in over her head, panicked, and decided to blame the neighbor for her mistakes. I felt something crack inside my chest. Can he do this? Can he just lie and have it work? Not permanently. But he can buy time, and in litigation, time is currency. More time means more legal fees. More time means more stress on you personally. More time means the chance that you might give up because the emotional cost becomes too high. So what do we do? Richard leaned back in his chair. We have options. We can go for a summary judgment motion, essentially asking the court to rule in our favor without a full trial because the evidence is so clear. That's faster but not guaranteed. We can pursue a settlement that acknowledges the encroachment and requires him to remove the structures or compensate you properly. Or we can prepare for full litigation and let a judge decide everything. How much are we talking? I asked. In terms of money? The value of the encroached land, if we're using current market rates and accounting for the structures that would need to be removed. Probably somewhere between $180,000 and $240,000 depending on comparable sales in your area. That's what you could theoretically recover. The number was so large it didn't feel real. It felt like something from a movie, or a lawsuit you heard about on the news, the kind of thing that happened to other people. But litigation costs, Richard continued, could run us $15,000 to $30,000, depending on how far this goes and how hard he fights. The depositions alone will be expensive. Expert witnesses, discovery motions, probably at least 3 or 4 court appearances if we go all the way. I did the math in my head, and the calculation made me lightheaded. This was the thing nobody tells you about fighting back, that winning might cost nearly as much as what you're fighting for. There's also a reputational element we need to consider, Richard said carefully. He's going to try to make this about you, not about property boundaries. He'll claim you're unstable, that you're making things up, that you trespassed on his property, possibly to steal documents or gather information. None of it's true, but it's a narrative. And if this goes to trial, if it gets adversarial, people in your neighborhood are going to know about it. So he wins either way, I said flatly. If I back down, he wins. If I fight, he wins because he makes me look crazy. Not necessarily. Richard stood up and walked to his window, looking out at the city below. I've been doing this for 30 years, and I've learned that people like your neighbor operate on a specific assumption, that their opponents are rational actors who will calculate cost and benefit the same way they do. They assume that once you understand the financial and emotional price, you'll fold. What he hasn't accounted for is that you might not. What do you mean? He turned back to face me. I mean that sometimes the nuclear option is the one that actually works. Sometimes, when someone is expecting negotiation, what breaks them is the absolute certainty that you're willing to burn the whole thing down to get justice. You want me to threaten him? No. I want us to file the complaint. Richard walked back to his desk and pulled out a blank legal form. I want us to formally sue him for the value of the encroached property, and I want to do it tomorrow. Before his lawyer can file any protective motions. Before he can build more of a narrative. I want to get ahead of this. That's going to make him angrier, I said. Probably. But right now, he thinks he still has leverage. He thinks you're scared. Once he realizes you're willing to fight this all the way, his entire strategy changes. And sometimes, that's when people actually start listening to reason. I thought about Gerald on his deck in the darkness, the satisfaction in his voice when he thought he'd caught me in something. I thought about the way his posture had changed when I told him what I knew. Okay, I said. File it. Richard nodded and began making notes. Then we need to talk about what comes next, because this is where it gets real. #Chunk6. The complaint was filed on a Tuesday morning at 9:47 a.m. I know the exact time because Richard sent me a confirmation email with a timestamp, and I stared at it for 20 minutes like it might spontaneously combust on my screen. It's done, his message read. The court has it. Gerald will be served within 48 hours. We should expect his attorney to respond within 14 days. In the meantime, document everything. If he contacts you directly, do not engage. Refer him to me. I read it 4 times. Each time, my stomach twisted tighter. I told myself I was ready for this. I'd spent 2 weeks mentally preparing, going through worst-case scenarios with Richard, understanding the financial implications, accepting that my life was about to become exponentially more complicated. But there was a difference between intellectual preparation and the moment when it actually happened, when the abstract became concrete, when my signature on a legal document became an official claim that I was suing my neighbor for nearly $250,000. I took the rest of the day off work. I couldn't focus anyway. My hands had a tremor I couldn't control, and I'd already made 2 errors on a project that required me to redo 45 minutes of work. My boss had asked if I was feeling okay. I'd lied and said it was just a migraine coming on. The half-truth sat uncomfortably in my chest. By Wednesday afternoon, Gerald was served. I knew because I saw the process server's car pull up to his house from my kitchen window. I'd been standing there for no good reason, staring out at the backyard that I now technically owned more of, watching the way the afternoon light caught the pool house Gerald had built on my land. The process server, a woman in business casual with a clipboard, walked up to his front door, waited, then left an envelope with what I assumed was his copy of the complaint. I watched Gerald come out about an hour later. He stood in his driveway holding the envelope, and even from this distance, I could see the moment he opened it. His entire body went rigid. He read it once, then again, then stood there for a full minute just staring at the pages. Then he looked up. Directly at my house. Directly at my kitchen window where I was standing, frozen, suddenly very aware that I was watching him and he was watching me watching him. I stepped back quickly, my heart hammering against my ribs. It was absurd. I had the right to look out my own window, but there was something about his gaze that felt like contact, like an electric shock through the glass between us. That night, Richard called. His attorney responded faster than I expected, he said. She filed a motion to dismiss, claiming the complaint lacks sufficient basis and that the adverse possession claim negates our standing to sue. It's boilerplate, expected, but it means he's hired someone competent. That's going to raise his costs significantly, which is actually good for us long term. What does that mean? I asked. It means we'll file a response to his motion, and the judge will decide whether this case has merit. Given our survey documentation, the judge will almost certainly deny his motion to dismiss. But it buys him time, and it signals that he's willing to dig in for a fight. Okay, I said slowly. There's something else. Richard's tone shifted, becoming the careful, measured voice he used when he was delivering information he knew I wouldn't like. Gerald's attorney sent a letter to your employer. I sat down very slowly. What? She's claiming that your actions, specifically your trespassing on their property to gather documents and your pattern of harassment, constitute criminal behavior. She's asking that your employer review your conduct and verify that they have no liability for employing someone engaged in potentially illegal activity. The room tilted. Can she do that? Technically, yes. It's unethical, but not technically illegal. She's trying to weaponize your employment. If your employer gets nervous about liability, they might distance themselves from you or terminate your employment. It's a pressure tactic. But I didn't trespass, I said. I went to his front door like a normal person. I know that. And your employer will know that. But it plants a seed. It raises questions. And for some employers, questions are enough to create distance. I spent the next 6 hours in a state of anxiety that made the earlier tremors look like nothing. I didn't call my boss. Richard had advised against it. Don't proactively volunteer information unless asked. If they ask, direct them to me. But every email that came through made my chest clench. Every moment I wasn't actively working, I was imagining conversations I wasn't part of happening in offices I didn't have access to. By Thursday, I still hadn't heard anything from my employer. That was somehow worse than if they'd already said something. What was worse, though, was what happened Friday morning. I came home from getting coffee to find a new fence installed along the eastern side of Gerald's property, the same side that the survey showed he'd been claiming 3 additional feet on. It was professional work, clearly done by a contractor, done with precision and speed. It cut even deeper into what I knew was my property, and it was done without notice, without communication, without any pretense of negotiation. It was a middle finger, rendered in treated lumber and steel posts. I called Richard immediately. It's deliberate provocation, he said after I'd explained. He's trying to get a reaction out of you. Don't give it to him. Document it, take photos with a timestamp, multiple angles, and send them to me. But do not under any circumstances go over there, do not cut the fence, do not confront him. That's exactly what his attorney is trying to bait you into. He's putting up more fence on my property, I said, hearing the rising pitch in my voice. He's actively expanding the encroachment while we're litigating about the encroachment. I know. And that's illegal. And we'll address it. But we address it through the court, not through the driveway. Understood? I understood. But understanding and accepting were different things. The following week was the worst yet. My employer's HR department called me in for a meeting. It was brief, professional, and ended with them assuring me they had full confidence in me and saw no issue with the matter, but I could feel the shift in the room's temperature. They'd received the letter. They'd had to discuss it. The fact that they concluded nothing improper had occurred didn't erase the fact that my name, my integrity, and my employer's liability were now entangled in the same sentence. I went home that day, sat in my kitchen, and looked out at the new fence. Gerald had been right about one thing, it turned out. This was going to be expensive. Just not in the way either of us had imagined. #Chunk 7. The motion to dismiss hearing was scheduled for November 15th. That gave us 6 weeks to prepare, which Richard assured me was adequate time, though the way he said it suggested he meant we'd have just enough time and no more. We had a phone call every Tuesday where he walked me through where we stood, what documents we still needed, and what new complications had emerged. There were always new complications. 2 weeks after the fence went up, Gerald's attorney filed a counterclaim. She was arguing that we had damaged his property by conducting an invasive survey, without permission, that we trespassed multiple times to gather evidence, and that our entire legal action was malicious and designed to harass him. She was seeking damages of $50,000, plus attorney's fees. Richard explained that counterclaims were common, that judges often dismissed them as retaliatory nonsense, but I understood what was really happening. Gerald was turning up the pressure, making this more expensive, more time-consuming, more complicated. It was working. My sleep had become unreliable. I'd fall asleep around midnight, wake up at 2:47 a.m. panicking about some detail. Had I documented the fence properly? Were my photos timestamped correctly? Did I have the right receipts for the survey? And then lie there until dawn, my brain cycling through catastrophic scenarios. What if I'd made an error in the complaint? What if the judge decided that even though Gerald's encroachment was real, my response had been disproportionate? What if? I started taking walks around the neighborhood at odd hours. There was something about movement that helped settle the anxiety, though I was careful never to walk past Gerald's property. I didn't want to give his attorney any ammunition. See, Your Honor, the plaintiff was actively surveilling my client's residence at 6:15 a.m. The paranoia was exhausting, but I couldn't afford to dismiss it. He'd already shown he'd weaponize anything. The worst part was the silence from his side. No more aggressive letters, no more calls, no more fence installations. Just nothing. Which somehow felt more threatening than the noise. He was letting his attorney do the talking now, and that attorney was competent and vicious in ways that Gerald's bluster could never be. Richard decided we needed to file a motion for a preliminary injunction, a request that the court force Gerald to stop expanding the fence and remove what he'd already built until the case was resolved. It's the right move legally, Richard said during our Tuesday call in late October. But I want to be clear, this escalates things. This signals that we're not interested in settlement negotiations. This is us saying we're willing to go all the way. I thought we were already all the way in, I said. There's always further, he replied, and the weight of that statement sat with me for the rest of the day. The motion was filed on November 2nd. Gerald's attorney responded within 5 days with a brief that was, in Richard's assessment, creative and aggressive. She argued that the fence was necessary for Gerald's safety and privacy, that we hadn't suffered any irreparable harm, and that granting an injunction would constitute judicial overreach. She included photographs of my house taken from Gerald's property, photos of my back patio, my garden, my pool area. She was building a narrative that I was the one behaving aggressively, that I was the one who'd initiated this conflict by refusing to negotiate. I called Richard in a panic when I saw those photographs. He's been photographing my house. For documentation purposes, presumably, Richard said, though his tone indicated this bothered him too. But we'll address it. We can file a motion seeking sanctions for the introduction of photographs obtained through trespass. He's trespassing. He claims he was standing in his own yard. The angle of the photo suggests he might have been standing at the property line or near it. It's murky, but it's worth flagging. Richard paused. I need you to understand something. This is the nature of litigation. It's not always clean. It's not always fair. What it is a process. And the process protects you, but only if you stay in the process. You don't step outside it, you don't retaliate outside it, you don't let emotion drive you outside it. Can you do that? I don't have a choice, I said. You always have a choice, Richard corrected. You're choosing to stay the course. That's good. Keep choosing it. The hearing was approaching like a storm front. I could feel the pressure building, the air getting heavier. My work performance had recovered somewhat. I'd been able to compartmentalize better in recent weeks, but there were still days where my concentration felt fragile, like it might shatter if Gerald so much as looked at me wrong. Then, 2 weeks before the hearing, something unexpected happened. I was getting mail, as you do, and among the bills and advertisements was a certified letter from Gerald's homeowner's insurance company. They were requesting copies of all documents related to the property dispute, specifically the survey and the photographs of the fence installation. Richard explained that this meant Gerald had filed a claim with his homeowner's insurance, likely claiming that the encroachment issue had originated from a negligent survey or some other covered event, trying to get his insurance company to fund his legal defense. Which means, Richard said slowly, that his insurance company is now invested in this outcome. Which means they have their own attorney looking at the facts. And if their attorney looks at the survey and the photographs and the timeline, they're going to reach the same conclusion we did: Gerald is liable, and his insurance probably doesn't cover intentional encroachment anyway. So it's possible, just possible, that his insurance company decides his claim isn't worth defending, and they drop him. That would leave Gerald paying for this entire legal battle himself, out of pocket. That changes the calculus dramatically. For the first time in weeks, I felt something that wasn't anxiety. It was a small feeling, fragile and uncertain, but it was there, hope. The hearing was 10 days away. #Chunk 8. The morning of November 15th dawned gray and cold. I'd been awake since 4 a.m., though I hadn't bothered trying to fall back asleep. Richard had called me the night before to go through the presentation one final time. We weren't asking for much, he'd reminded me. Just a preliminary injunction stopping Gerald from further encroachment and requiring him to remove what he'd already built until the case was fully resolved. A temporary measure while the courts figured out who actually owned what. I wore a gray suit I'd bought specifically for this hearing. It fit well, made me look competent and serious, which was the entire point. Richard had been clear: judges respond to presentation. I arrived at the courthouse 30 minutes early and sat in the hallway outside the courtroom, watching people flow past. I recognized Gerald when he arrived with his attorney, a sharp-looking woman in her 50s with steel gray hair and an expression that suggested she'd never experienced a moment of doubt in her life. Gerald looked smaller than I remembered. Not physically, he was still a broad-shouldered man in an expensive suit, but diminished somehow. His jaw was clenched, and he kept glancing at his attorney as if checking whether he was supposed to be feeling confident about this. Then I saw something that made my breath catch. Gerald's insurance company attorney was there. Richard had warned me this might happen, but seeing it in person was different. The man was sitting separately from Gerald and his attorney, which I took to mean his allegiance was currently undecided. Richard arrived 5 minutes before the hearing was set to begin. He looked calm in a way that suggested this was just another Tuesday for him, though I knew better. We'd worked together on this for months. He'd seen my anxiety, my sleeplessness, my fear. If he was calm, it was a choice he was making. "How are you feeling?" he asked. "Like I'm about to throw up," I said. "Good. That means you understand the stakes. You won't make careless mistakes." He paused. "We're going to win the preliminary injunction. I don't say that lightly. The survey is bulletproof, the timeline is clear, and the photographs document everything. What we need to do in there is present those facts calmly and let them speak for themselves." "Understood." I nodded. The courtroom was smaller than I'd expected, and Judge Patricia Hutchins was already on the bench when we filed in. She was a woman in her 60s with reading glasses on a chain and an air of someone who had long ago stopped being impressed by anything. The proceeding began with the formalities: statements of the case, introductions of parties. Then Richard stood and walked through the evidence methodically. He presented the original survey, showing Gerald's fence and deck clearly situated on my property. He presented the photographs, time-stamped and labeled. He presented the property deed. He presented the county records. It was all so straightforward, so obvious, that I found myself wondering why we needed to come to court at all. Then Gerald's attorney stood up. She was good. I'll give her that. She spoke about Gerald's good faith, about how he'd purchased the property in good faith based on the existing fence and landscaping, about how he'd made improvements based on what he reasonably believed to be his property. She argued that forcing him to remove a $40,000 deck and pool house would constitute irreparable harm to him. She painted a picture of an innocent man being persecuted by an aggressive neighbor. It was compelling. It was also bullshit, but it was compelling bullshit. Judge Hutchins listened without expression, asking occasional clarifying questions. I couldn't read her at all. Then something happened that I didn't expect. Gerald's insurance attorney stood up. Your Honor, she said, I want to be clear about my client's position. We are here as an interested party only. However, having reviewed all relevant documentation, it is our assessment that this encroachment appears to be intentional rather than inadvertent. Our insured's homeowner's policy does not provide coverage for intentional acts. Therefore, my client is not in a position to fund this defendant's legal defense, and we are withdrawing from these proceedings. The courtroom went very quiet. Gerald's head whipped toward his insurance attorney, then toward his own attorney. His attorney's expression didn't change, but I saw her jaw tighten. Judge Hutchins nodded slowly. I see. Ms. Chen, does your client understand the implications of his insurance company's withdrawal? Gerald's attorney stood. Your Honor, my client is prepared to proceed pro bono if necessary. It was a lie. I could tell by the way she said it, by the careful way she didn't look at Gerald when she said it. Her client wasn't paying her anymore, his insurance company had just cut him off, and now she was figuring out whether this case was worth continuing without a paycheck. Judge Hutchins set down her pen. Let me state my findings for the record. The survey presented by the plaintiff is professional, thorough, and consistent with the county records. The property line is clear. The defendant's fence, deck, and pool house are located on the plaintiff's property. This is not a close call. There is no ambiguity here. The defendant argues that he acted in good faith. However, the plaintiff's counsel presented certified correspondence from the defendant explicitly stating his understanding that the property line was disputed and that the plaintiff had challenged his interpretation. This indicates the defendant was aware of the dispute and proceeded anyway. That is not good faith. I am granting the plaintiff's motion for a preliminary injunction. The defendant is ordered to cease all further construction or expansion on the disputed property. The defendant is ordered to remove the fence, deck, and pool house at his own expense, with work to be completed by January 15th of next year. Failure to comply will result in contempt of court proceedings. Furthermore, given the defendant's apparent intentional encroachment and the presentation of evidence suggesting the defendant engaged in conduct designed to intimidate the plaintiff, I am imposing sanctions of $15,000 to be paid to the plaintiff to offset legal costs. The words washed over me, and for a moment I couldn't process them. We'd won. Actually won. Not a settlement, not a compromise, but a complete, unambiguous victory. Gerald's face had gone very red. His attorney was already gathering her papers, her expression suggesting she'd mentally fired him approximately 30 seconds ago. Furthermore, Judge Hutchins continued, would advise the defendant that his conduct throughout these proceedings has been noted. If this case proceeds to full trial, I will be considering his behavior in determining any additional damages or sanctions. I would strongly encourage him to take this loss and move on. The hearing was over. Dismissed in the manner of someone who had already spent too much time on a case with an obvious outcome. Richard squeezed my shoulder. Congratulations, he said simply. I walked out of the courtroom in a daze. Gerald didn't follow. His attorney had already left, presumably to call her malpractice insurance company. It was over.